Okay, hello, Political Science 1. Going over Chapter 5 with you guys. I'm going to get started because this is a long chapter. So we're looking at the judicial branch. So when we look at the power problem with the judicial branch, how much power should the judicial branch have? That's pretty much the main idea behind the judicial branch. Should they be able to make law? That's a debate that people have had about who should be more powerful. The legislative branch is the one that makes the law. Well, the judicial branch tends to take that over as well by declaring laws unconstitutional. So they can create law from the bench. So when we talk about the power problem with the judicial branch, should they be able to make laws or not make laws? And we'll go over that in a slide in a little bit. We have different eras of the court. I'm gonna go past these pretty quickly because I'll let you go through those when you do your notes or your outlines for this chapter. You definitely should know Marbury versus Madison. The courts can declare laws unconstitutional. That is a super important case. Please know that for test purposes. Gibbons versus Ogden. Congress has power to regulate interstate commerce, not the states. I'm not so stressed about that one. McCulloch versus Maryland, you should know. That establishes the idea of implied powers. It allows Congress to make laws that are necessary to fulfill the enumerated powers. So McCulloch versus Maryland establishes implied powers. So that is an important case you should know for the test as well. When you look at these rulings, they increase national power. So these first few set of rulings, in this founding era, gives more power to the national government versus state governments. Whereas the Taney Court believed in dual federalism, the national government and state governments work on different policy areas. Power shared and it gave more power back to the state. So those first few rulings give more power to the national government, whereas this ruling gives more power back to the state governments. Dred Scott versus Sanford. Slave must return to his master because he is property of the state that allows slavery. So in this instance, the court sided with the state instead of the national government, and so the slave had to go back to their owner. I'm not worried about economic regulation areas. We'll just skip over this. The era of liberal nationalism. The court is giving more power back again to the national governments. I'm not worried about Roosevelt versus Connecticut. Mapp versus Ohio is good, but that's probably good for Chapter 18. It sets up the exclusionary rule. Miranda versus Arizona established Miranda rights. Again, we'll go over this. We'll go over these more in depth when we get to Chapter 18. Roe versus Wade with abortion. And today, or in the last 20 years, the court has been more conservative. They've been tougher on crime and more protection of businesses. All right, so when we talked about earlier, when we talked about how much power should the courts have, well, in here, judicial proper role, we have judicial activism. The court can create laws, so if you are a judicial activist, you believe that the court should be able to make laws. Whereas judicial restraint is more constructionist. They follow along what the Constitution says. So strict adherence to the Constitution and elected branches. Let the judicial branch or let the legislative branch make the laws, and how the executive enforces the laws, that's how they do it. So judicial activism is create law, judicial restraint is not. Judicial review is important. We've talked about it. You need to know this case, Marbury versus Madison. Marbury versus Madison is important because it establishes judicial review. This is the only power the court has. So what you need to remember about judicial review is the only power the court has. And really, what judicial review is, it allows the Supreme Court to find laws unconstitutional. If a law goes against the Constitution, it can be thrown out because it goes against the Constitution. So that's why this case is important. This is the only power really the court has, is to declare laws unconstitutional. All right, cases. Judiciary operates only in the context of cases. A case must be brought to the courts for them to function. So cases have to follow certain rules. If you're not read your rights, if you have a confession beaten out of you, that case can be thrown out against you. Two types of cases that we're dealing with, or that the court deals with: criminal cases. So these cases are public wrong against society as a whole. So your normal criminal cases, murder, rape, theft, those are crimes. They are against society as a whole. Whereas civil cases attempt to redress a private wrong or settle a private dispute. So these are lawsuits. So civil cases are lawsuits. So if somebody rear-ends your car and they don't have insurance, you can sue them in a civil case to give you back your property or to restore your property. So crimes are public, civil is private. There are 51 judicial systems in the United States. There are 50 state judicial systems and one national government. So California has its own court system. Nevada has its own. Different states have different laws. So California has its own laws. Nevada has its own laws. In Nevada, you can gamble, right? Whereas in California, you cannot. So different states, different laws. So state courts and federal courts. Almost all divorce and personal injury cases are heard in state courts. So when who recognizes marriage? Is it national government or state governments? State governments do. So divorce laws are different from state to state. Same thing with personal injury cases or lawsuits. Those are all heard in state courts. Antitrust laws and violation of federal criminal laws are heard in federal courts. Antitrust is monopolies. If a company is set up a monopoly, the federal government can get involved. That's their jurisdiction. So state courts have their own set of laws, and then the national government has its own set of laws. And those court systems deal with those things. So jurisdiction, authority of the court has to entertain a case. Who has the right to oversee a case? If it's a murder crime, most murders are handled by states. So that's state jurisdiction. If we're looking at fraud, killing a federal official, those are federal crimes, and that's federal jurisdiction. Then you go to federal court. So those are the differences between state courts and federal courts. Depends on if you're violating state law or federal law. Counterfeiting is only done by the national government, so that is a federal crime. All right, so let's look at state courts and then local courts. This would apply to California. These courts are set up by the laws of the constitutional state with which they reside, so California has its own legal system. Most crimes that are committed are against state law. Speed limits are different from state to state, right? In California, I think the most is 75. In Arizona, it's 80. In Montana, it's 90. So different states have different speed limits. So when you speed, you're committing a crime against state law. So most Americans who go to court will go to state or local courts. So you'll go to, when you're doing your speeding, you'll go to Kings County or Fresno County, the Fresno County Superior Court, and you'll be adjudicated there. Most courts have a 4-tier judicial system, so there are 4 levels to each to California system. The lowest level are courts of limited jurisdiction, so they're limited in their scope and what they oversee. So lowest court. Particular types of cases, so what we're looking at is your traffic violations, small claims, juvenile affairs, domestic matters, minor criminal offenses. So all when you get pulled over for speeding, your name actually shows up in court when they render a fine. So these are courts of limited jurisdiction. Next level, courts of general jurisdiction. So the courts of limited jurisdiction, they only look at very small, limited things, whereas the courts of general jurisdiction is pretty much most any other crime or civil case. Located in each county, so Kings County has its own, Fresno County, Tulare County, they have their own court systems. They hear appeals from the courts of limited jurisdiction. Appeals means that if you don't like the ruling in a lower case, you can go to the next higher court to have it overturned. Also, serious criminal offenses, so your murders will happen here. Civil suits involving large amounts of money, so when you're suing a car company because of a defect in the car, that's probably a large amount of dollars, so you're going to start in the courts of general jurisdiction. In California, they're called superior courts. When you get your jury summons, you should get a letter from Superior Court of California or Superior Court of Kings County or Fresno County. That's the Superior Court. Intermediate appellate courts is the third level, is the next higher level. If you do not like the ruling of the lower court, the court of general jurisdiction, you can go to this appellate court and appeal that decision. Try to get it overturned. Really, all they hear are appeals. That's it. There's nothing else that they do. No cases go straight to them. It's only appeals from the superior courts. And then you have the state Supreme Court, sometimes called the court of last resort. Highest court in the state. No other state court can contradict the state Supreme Court. The federal Supreme Court can get involved, but there has to be a federal question in their jurisdiction. And they hear appeals. So if you don't like the ruling of the intermediate appellate courts, you can go to the state Supreme Court and try to get it overturned as well. All right, so the federal court system. So that was state courts. Now we're looking at federal courts. Federal court system is a three-tier system, so there are 3 levels to the federal court system. You have U.S. district courts, set up by the Judiciary Act of 1789. So one of the enumerated powers given to Congress is to set up a national court system. So this is what they do, is the Judiciary Act of 1789 to set up a national court system. So it's an organization separate from the state's court system for the entire country. All federal cases are heard in U.S. district courts. So any federal crime starts off in the district courts. So again, fraud, counterfeiting, killing a federal official, those are federal crimes. So what's their jurisdiction? I've gone over some. Extends the case that arise under the Constitution. Should we have to say under God and the Pledge of Allegiance? Laws and treaties of the United States. If we're in violation of treaty law, that goes to federal district courts. In the maritime cases, maritime is on the sea. So any crime that's committed, that's probably federal jurisdiction on the sea. You have the Court of Appeals, pretty much just like the name says, they hear appeals. And instead of having one judge sit on it, you'll have 3 judges sitting on a case. Most of these cases come from the lower courts. So pretty much it's just, you don't like the decision of the lower court, you go to the next higher court, which is the Court of Appeals, to try to have it overturned. You also can review rulings of various administrative and regulatory agencies of the United States or of the national government. So back to Chapter 4, the bureaucracies. If you do not like the rulings of those bureaucracies, you can go to the U.S. Court of Appeals and try to get those rulings overturned by those bureaucracies, like the IRS or Defense Departments, any of those agencies that we talked about in Chapter 4. Of course, the big enchilada is the Supreme Court. This is the most important court of all the courts in the United States. They have the most powerful, they're the highest court in the United States. No court can contradict the Supreme Court. So highest court in the United States. They hear appeals from the lower courts if they want to take those appeals. Also going to look at cases that raise a federal question. Who's going to be president of the United States? If there's a constitutional question there, the Supreme Court can take that case right up to them. Matters involving the interpretation of the Constitution or a statute or treaty of the United States. What does the Second Amendment really mean? Is it the right of an individual to carry a weapon, or is it the right of a state to have a militia? That's an interpretation of the Constitution, so the Supreme Court will look at those types of cases. Or again, saying under God and the Pledge of Allegiance. All cases will reach the Supreme Court through a writ of certiorari, Latin meaning to be informed. Anytime there's a Latin word or Latin phrase, you'll want to remember that, especially when we're talking about law. So you'll want to remember writ of certiorari. This also fits in with the essay question that comes out of this chapter. It takes a minimum of 4 justices to agree to hear a case or accept a case for review. So there's 9 judges on the Supreme Court. You have to get 4 of them to agree to take your case. Don't worry about this last slide. I need to erase this because it doesn't fit in. Federal judicial selection. We should probably know these. These are enumerated powers that are stated, but we'll go over them. All federal judges are selected by the president. So the president will pick who the judges are. All federal judges must be approved by the Senate. So the Senate, all these judges will go before the Senate. The Senate will hold hearings and then vote on if they allow them to serve or not. All federal judges are appointed for life. So they're in for life until they retire or die. They are judges for life. They can be impeached as well. What do presidents look for when they pick a judge? So we're going to go through these quickly. Pretty simple. How do you get professional qualifications? Somebody goes to Harvard. Did they go to Stanford? What law school did they go to? So professional qualifications. How long have they been a lawyer or a judge? Acceptability to the Senate. It is bad for a president if their pick does not make it through. It looks bad on the president. So they want to pick somebody that can get through the Senate easily. Ideological fit. You want to pick somebody that thinks like you do. If I am pro-choice, am I going to pick somebody that's pro-life as a judge? You want to pick somebody that thinks like you do. Personal friendship. How do you get your first job? It's who you know, right? So that's kind of the same thing here. I'm going to put my friend on the Supreme Court. And then region, race, religion, gender, and other background factors. If I'm president, if I pick somebody that's a woman, hopefully that will get more women to vote for me. So presidents take these factors into consideration as well. Precedent emanating from stare decisis or standing on decided cases. You've heard this if you watch legal dramas. They talk about precedent. It's using previous cases to help you make your decision on the current case you have. That is precedent. So use previous court rulings to help you make your decision. Especially if the Supreme Court has ruled on a similar case, you do not want to contradict the Supreme Court. You'll follow what the Supreme Court said. So you're using their ruling from a previous case to come up with your ruling. That's known as precedent. You'll want to remember this for the essay question, which is this right now. You're going to need to tell me how the Supreme Court takes and hears a case. So we're going to go through it right now really quickly because we got about 3.5 minutes left. First thing you have to do is when you lose in the lower court, you have to give a petition for review and a writ of certiorari. We talked about writ of certiorari earlier. I know it's hard to read, but it's earlier on. When you lose a case in lower court, you must file the petition with the Supreme Court to hear your case. So you lose, you need to file this petition with the Supreme Court to accept your case. So you're going to try to tell the judges why they need to take your case or not take your case, and that the questions the case raises are important or unimportant, that it needs the court's attention. So in this petition, you're telling them why they should take your case or why they should not take the case. So you're trying to convince the judges why they should or should not take your case in the petition for review. Again, through writ of certiorari, you're telling them that you're informing them that you're bringing a case. How many judges do you need to agree to take your case? You need to have 4 judges to take your case, the rule of 4. It's known as the rule of 4. So you have to get 4 judges to agree to take your case. When they take your case, then they ask for the briefs on the merit. Second set of briefs. In these briefs, you're going to give them all the arguments that you're going to give in court. So they want all the arguments beforehand. Why do they want all the arguments? So that they know what you're going to argue, so they can do research and see if there are similar cases that they can draw off of. Okay? So they want to know all the arguments that you are going to make before you make the arguments. After they take your briefs on the merit, study them, then they set your court date, and then they hear oral arguments. So each lawyer has about an hour to make their arguments in front of the Supreme Court. All 9 justices can ask any questions they want during oral arguments because they know all the your arguments that you're making beforehand. So they're going to question you on, did you take this other case into consideration when you're making this argument? So they're going to ask you a bunch of questions as you are making your case. So opposing lawyers face the justices. Each justice has an opportunity to ask questions because they know all the arguments that you're making from the briefs on the merit. After they are done with oral arguments, then they go back in conference. The justices will discuss the case and try to sway each other to their respective sides. So they're trying to bring each justice onto their side. The more justices you get to agree on your side, the better the decision is. A 9-0 decision is way better than an 8-1 or a 7-2 or a 6-3. You want to get all judges on your side. Then you have the decision. The decision may come weeks or months after the case is heard in court. So it could take a couple months. It could take up to a year to get a decision. But then you get the decision. Last part of this is writing of the decision. Decision must be assigned and written by one of the justices from each side, majority and minority. The goal is the opinion of the court. So you want a written decision because it sets stare decisis. It sets precedent. so that if another case comes along that's similar to this, they will use this case to come up with their decision. So that's why the written decision is probably the most important part of the whole process. So those are all the steps you need to go through if I was to ask this essay question. Last part of the essay question will be what are the different decisions and opinions of the court. So types of decisions, there's affirm, reverse, and remand. I'm going to go through these quickly because we're running out of time. Affirm, you agree with the lower court ruling, so they keep the lower court ruling. Reverse, you don't agree with the lower court ruling. You overturn the lower court. Remand, it's kind of a, you made a mistake, take it back and fix it. So if I remand back your paper, I'm giving it back to you for you to fix it. Types of opinions, these should be easy. Unanimous, all 9 agree. So unanimous decision or opinion. Majority, 5, 6, 7, 8, that's the majority. They come up with their opinion. Why did they vote the way they did? Concurring, I agree with the majority, but my reasoning is different. So when we talk about concurring opinion, I agree with the majority, but I have different reasoning that I got there. So I concur with the majority, but my reasoning is different. And then dissenting is the minority opinion. Dissenting, I dissent from the majority. So the dissenting opinion is the minority opinion. All right. Thank you guys. That's it for Chapter 5. We will talk to you in Chapter 6.